Okay, so now, Sandy?
Yeah, I'm Sandy Levinson. I'm delighted to be here, and I welcome all you to this panel. There's something obviously extraordinarily amusing about the title, that is Complexifying Religious Accommodation, because I'm sure all of us agree that the earlier panels were just a piece of cake. There was nothing complicated about any of them, but now we will complexify the issues. That having been said, we're going to have a slightly different format. The four papers, more or less, can be put in clumps of two. And so we're going to do two presentations and then break for some questions or any comments by the panel, and then the other two papers. The first two, John Inazu on A Confident Pluralism, and then Anita Allen on Veiled Women in the American Courtroom, Is the Niqab a Barrier to Justice?
Well, thanks. It's a pleasure to be here, and thanks especially to the organizers for making this event happen. I'm going to step back and talk a little more conceptually about some of the issues as I've been thinking about them, speaking about the values underlying a pluralistic vision of society. And I think there'll be echoes of some of Nan's comments and also Kenji's as well. But I want to start by introducing a case that I don't think has been mentioned yet today. I wasn't here last night, and that's Christian Legal Society against Martinez from the 2010 term. And so I'll revisit the facts briefly and then move forward. As many of you know, this case involved a challenge to the student organization policy at Hastings College of the Law, a public law school in San Francisco. Hastings permitted students to form interest groups of their choosing. These officially recognized groups could use classroom space, recruit members, and receive modest funding. Hastings also enforced an all-comers policy that required all student groups to accept all interested students. The Christian Legal Society at Hastings welcomed anyone to attend its meetings, Bible studies, and prayer sessions, but it insisted that its members adhere to a creedal statement that included a belief in Christianity and a moral conduct code. The code required, among other things, that members limit sexual activity to marriage between a man and a woman, so there was clearly this tension that we've been talking about today, religion and gay rights in this particular context. And after Hastings enforced its all-comers policy to deny the society official recognition, the group sued in federal court. The Supreme Court upheld the all-comers policy in a 5-4 decision, and it's widely viewed as a victory for the left in the culture wars. But I want to suggest today this enthusiasm for Martinez is misplaced because the legal reasoning underlying the decision compromises the political value of pluralism, the notion that we can and must live with genuine difference. As an amicus brief for the group Gays and Lesbians for Individual Liberty argued, we seek our shared goals through a confident pluralism that conduces to civil peace and advances democratic consensus making, not by abridging First Amendment rights. And that's the title of Confident Pluralism of my talk, and maybe a book comes from that brief. The underpinnings of this confident pluralism are echoed by prominent progressive scholars. Kenneth Karst insists that one of the points of any freedom of association must be to let people make their own definitions of community. Professor Eskridge reaches a similar conclusion. The state must allow individual communities to flourish or wither as they may, and the state cannot, as a normal matter, become the means of triumph of one community over all others. And David Richards reflects the best of American constitutional law rests on the role according resisting voice and the worst on the repression of such voice. The idea of a confident pluralism builds on these intuitions. But because pluralism's earlier and contemporary meanings are varied and contested, it's important to specify what I mean by pluralism in this particular argument and to what I mean the concept to apply. So I want to begin with the latter. Along with Professor McConnell and a host of other scholars, I focus the arguments for a confident pluralism on the non-commercial groups of civil society. So nothing I have to say here has anything to do with Elaine Photography or Hobby Lobby or any other commercial group. As I've argued elsewhere, this line is imperfect and it's a pragmatic compromise that cannot be fully justified on principled or constitutional grounds. And it leaves open important and unresolved issues and examples like hospitals, universities, and private accreditation entities that, while formally non-commercial and non-governmental, nonetheless implicate important concerns about market and political power. And Professor Tebbe in a recent piece has pointed out many of these concerns. But notwithstanding these concerns, my claim is that the proposed line between commercial and non-commercial is preferable to either a strongly libertarian impulse that seeks protection of commercial groups or a strongly liberal egalitarian impulse that imposes shifting majoritarian norms on non-commercial groups. This imperfect and pragmatic line leaves the class of rights holders largely undisturbed by loosely approximating our historical and cultural understandings of civil society as that concept has been framed by thinkers from Tocqueville to Robert Putnam. Within this realm of civil society, I want to focus on three interrelated virtues of a confident pluralism: tolerance, humility, and patience. These virtues are ideologically cross-cutting in that they require something from each of us. And to see why this is the case, I'd like to describe the content of these virtues with a nod to Alistair McIntyre using two stock characters, the liberal egalitarian and the conservative moralist. I will assume that the liberal egalitarian desires progressive equality in the fashion of contemporary liberalism. Relatedly, he or she finds troubling the traditional gender and sexual norms reinforced by certain illiberal groups. In similar fashion, I assume that the conservative moralist seeks traditional morality along the lines of many conservative religious traditions. Relatedly, he or she finds troubling the more relaxed sexual norms reinforced by certain progressive groups. With these stock characters in mind, I turn to these three virtues of a confident pluralism. Tolerance, as I'm describing it, means a willingness to accept genuine difference, including profound moral disagreement. And in the context of pluralism, tolerance means moving beyond the platitudes of free speech to the more difficult questions imposed by the groups that make speech possible. The liberal egalitarian must tolerate illiberal groups, the conservative moralist must tolerate progressive groups. Contrary to some understandings of tolerance, I want to suggest that to tolerate something does not mean to accept its legitimacy or to embrace its difference as somehow wonderfully other. It does mean endorsing a presumption against government regulation of the private non-commercial groups of civil society absent an extraordinary justification. And for this reason, the truest test of tolerance admits that individuals in voluntarily chosen groups may in fact suffer moral harms, at least as perceived from the perspective of outsiders to the group. For tolerance to flourish, both the liberal egalitarian and the conservative moralist must bear the cost of knowing that unaddressed moral harms persist within the private groups of civil society. The virtue of tolerance also requires the hard work of distinguishing between people and ideas. The normative aspiration of pluralism is that we treat people with respect. That doesn't mean we respect all ideas. And to build on a point Andy made earlier today, every one of us in this room holds ideas that others in this room find unpersuasive, inconsistent, or downright loopy. And more pointedly, everyone in this room holds ideas that others in this room find morally reprehensible. I don't respect all beliefs, and neither do you. The tolerance of a confident pluralism does not impose the fiction of assuming that all ideas are equally valid or morally benign. It does mean respecting people, aiming for fair discussion, and allowing for the right to differ about serious matters. And I think this conference is an effort toward that. It takes real work, though, and maybe another way to put that is perhaps the most important part of this conference is not what anyone says tonight, but what we do at dinner. And maybe instead of sharing our views about Hobby Lobby and RIFRA, we could talk about 3 fun facts about ourselves or something like that and actually have a conversation. I know that's very hard, a tall order for academics, but we could try. The second virtue, humility, requires even greater self-reflection and self-discipline than tolerance. Within a confident pluralism, both the liberal egalitarian and the conservative moralist recognize that their own beliefs and intuitions rest upon tradition-dependent values that cannot be empirically proven or fully justified by forms of rationality external to particular traditions. The liberal notion of equality and the conservative notion of morality emerge from within particular traditions and practices whose basic premises are not endorsed by all members of society. Humility recognizes that we cannot presume shared foundations within our current political practices and their epistemic limits. The third virtue of a confident pluralism is patience, which recognizes that contested moral questions are best resolved through persuasion rather than through coercion. Our decisions about which actions to restrict are always a matter of contingent politics and often effected through the violence of the law rather than through an appeal to shared norms. Here it is important to recognize, and this is building on Kenji's comments earlier, that both the liberal egalitarian and the conservative moralist think that they are right in a profoundly deep way. That recognition is one reason that pluralism does not entail relativism. Our two stock characters and the millions of real citizens they represent structure much of their lives around their commitments to their moral values, and they usually aspire for their normative views to prevail on the rest of society. but the virtue of patience reminds them that a confident pluralism resists the appeal to state coercion unless absolutely necessary. This distinction between persuasion and coercion is, of course, not original to me. It has been advocated by a number of scholars. For example, Bill Galston has argued that pluralism requires a commitment to moral competition that is rooted in recruitment and persuasion rather than in coercion. And Corey Bretschneider has recently drawn a similar distinction between coercion and what he calls democratic persuasion. The problem with both Galston's and Bretschneider's proposals is that they fail to take seriously enough the ways in which coercive state power can substantially hinder or even eliminate the possibility of persuasion to a culturally disfavored moral position. For example, both scholars make broadly pluralist arguments but are quick to endorse the court's Bob Jones decision. The confident pluralism and the ideas that I'm talking about challenges that quick parsing. Indeed, this is one reason that I have argued elsewhere that the court's reasoning in Bob Jones is conceptually wrong, and it's important that I say conceptually, theoretically, doctrinally wrong. The federal tax code's recognition of deductions for contributions made to charitable or religious and educational organizations is functionally pluralistic because it effectively allows individual taxpayers to direct federal dollars to nonprofits of their choosing. Organizations and ideas wither or thrive not by government fiat, but based on what John Colombo and Mark Hall have characterized as the values and choices of private givers. We can think of these virtues of tolerance, humility, and patience as representing at a minimum the posture that individual citizens should assume toward the role of government in a pluralistic society. It may also be a normative aspiration that citizens adhere to these values in the pursuit and endorsement of non-governmental action, that it is better to tolerate than to protest, better to project humility than certainty, and better to wait patiently for the fruits of persuasion than for the consequences of even non-state coercion, like economic, social, and psychological pressures. But those are secondary to where I'm focusing the arguments normatively and constitutionally, where I want to focus primarily on government action. And of course, as many people have either mentioned explicitly or hinted at implicitly, these kinds of arguments now are facing a unique political moment. Pluralist arguments have traditionally come from those on the left who have challenged dominant and sometimes pervasive Christian, white, masculine, and heterosexual norms. Political power, though, is shifting, and gay rights is a great example to show us this. And here it's, I think, important to slow down for a minute and to say that while the debate and the politics are shifting, there are, as others have mentioned today, significant prejudices and bigotry still faced by gay and lesbian citizens, especially in some local communities. I think it's really important not to gloss over that reality, and my worry is that too many religious conservatives are quick to do so and take on sort of a reverse oppression narrative that fails to account for the changes we are in the midst of and the differences in localities. But there has been a change in the upper realm, the important realm of elite political and more recently cultural discourse, and that shift is going to continue and will remain an important dimension in arguments about pluralism. It's also important to emphasize in the midst of this shift that many religious conservatives did not embody the virtues of tolerance, humility, and patience in an earlier era when they held political power. Some religious conservatives previously supported coercive state action, but now might embrace a confident pluralism. They will rightly confront questions of whether their sympathies flow out of genuine commitment or political opportunism. But it is equally important to express at least two cautions about the critique of opportunism. First, it may well be that some religious conservatives have genuinely been persuaded by the pluralist argument. That persuasion may have arisen for all sorts of reasons, and it would be at the very least uncharitable to assume opportunism to the exclusion of genuine conversion. But there is an even more important reason to limit the charge of opportunism against religious conservatives as a class. Many religious conservatives may have subscribed to the virtues of a confident pluralism, even when those who shared more of their normative commitments held political power. That's another way of saying that the category of religious conservative is as underspecified as any other broad label cast in the culture wars. Consider by way of example theologian David Gushie's identification of millions of Americans in what he calls the evangelical center, who are socially conservative and who would reject important assumptions underlying liberal egalitarianism, but whose theological and cultural views are consistent with a confident pluralism. Of course, not everyone on the left or the right cares about pluralism or related First Amendment values. Many are more interested in political victory, and there is an alternative that refuses to sanction or permit difference viewed by those in power as closed-minded or bigoted, or in an earlier era as immoral or disgusting. but many people recognize that real difference is part of our shared existence, and that in most cases, the best way to deal with this difference is through tolerance, humility, and patience. Thank you.
Thank you. It's really nice to be here to see current colleagues like Sally Gordon and old ones like Mark Tushnet. I don't mean old, but former colleagues like Mark Tushnet and Bill Eskridge. It's good to see you all. And of course, my former teacher, Martha Minow, now Dean. Amazing. 30 years ago. Wow. Okay. So I want to offer some comments about a couple of cases that have occurred in the last several years. This takes me far beyond my realm of expertise. I'm not a First Amendment scholar at all, but I do think these issues are interesting, and I welcome your thoughts about my thoughts. So there was a woman in Michigan who had a minor small claims court type dispute with a rental car company. And so she went to court to have this claim adjudicated. And she walked into the courtroom wearing her niqab, her Muslim attire, and the judge said, "I can't hear your case unless you remove your niqab." So she said, "I can't remove my niqab. It's important to me." And he said, "Sorry, case dismissed." So she appealed that judgment. Another case, Canadian case, which ended up in the Canadian Supreme Court in a 2012 opinion that I find very interesting. But in the Canadian case, a Muslim woman got the courage to go to the police and accuse family members of having raped her repeatedly during her childhood. So she's going to be a witness, obviously, in this criminal prosecution. So the day of the preliminary hearing rolls around, they appear in the courtroom, and her own family members, the defendants, say, "Judge, you must order her to remove her niqab." And the court says, "Yeah, I think I should." So you have, both in Canada and in the United States, two very liberal, democratic, tolerant nations, a problem. The problem being that Muslim women of all races and backgrounds are faced with official governmental requests that they remove their hijabs or their niqabs or their burqas or all three, and we don't know quite what to do about it. And so I want to talk to you about how we might respond to this phenomenon. It occurred to me in the last week or so, far after this conference was announced, that some recent work by critical race philosophers, not legal theorists, but philosophers, might be helpful in this discussion, because a recent edition of the newly created Journal of Critical Race Philosophy is devoted to the topic of xenophobia. Back in 1991, an African-American philosopher named Adrian Piper wrote in an article called "Xenophobia and Kantian Rationalism" that xenophobia engenders various forms of discriminatory stereotyping: racism, sexism, anti-Semitism, homophobia, class elitism, through the pseudo-rational mechanisms of rationalization and dissociation by reducing the complex singularity of the other to a set of oversimplified but manageable properties that invariably diminish our full conception of personhood. And more recently, in the journal I just referenced, some of the authors of the papers argue that xenophobia is an important complement to the concepts of racism, unconscious bias, stereotype threat, because it focuses attention on the aspect of feeling threatened by, feeling afraid of, but also on the both the public and the private consequences of such emotive responses. Civic ostracism is what one of the authors calls the phenomenon that results from xenophobia. The others refer to the institutional problems that result from xenophobia becoming part of the system, the material system. So back to my cases. So I have a paper that's an essay coming out in a book, and I had actually had in my last book a chapter that also dealt with this topic. But the topic is, how should we deal with the question of whether women should be able to wear niqab in the courtroom? There are, well, I'll tell you my conclusion, because I might not get to it otherwise, right? But I advocate a position similar to that advanced by the Supreme Court of Canada. And this position calls for a presumption in favor of accommodating the niqab, so accommodation as the first step. And, but if the interest of the state and the interest of the woman are irreconcilable, then we have to engage in balancing, contextual balancing, highly contextual balancing, the court says. And this can result in the woman being allowed to wear her niqab in the courtroom or not, depending upon the circumstances. That resolution, try to accommodate, and if not, balance, and then see what the result is a very attractive one. In some ways, it appeals to my sense of being a moderate kind of a person. On the other hand, I think there is a stronger position, which was advocated by the dissenting judge in the same Supreme Court case, that actually might be a better way to approach this, and that I have great sympathy for. And this approach says, beware of balancing, but instead, recognize that the woman's stake here in being able to use the courts, both as witness, accuser, complainant, et cetera, is more important in principle than the interest of defendants and in open access to the face of the woman. And I think there's a lot to be said for that idea, because when we introduce the idea of balancing, in that context can come the problems of xenophobia, of civic ostracism, and prejudice that I think we have to be wary of. So, I want to tell you a little bit more about the Michigan case, the US case. I live in Philadelphia, outside Philadelphia. There are tons of women who wear burqas, niqab, and hijab. Sally's nodding. Every day, right? You just walk down the street in West Philadelphia, and there they are. A large native population of Muslim women who are wearing modesty attire, whether we feminists like it or not, they're there. Michigan has a very large population of both immigrant and native Muslims, and some, but not all, of the community women dress in Muslim attire. And the women who are so dressed have often zero ties to the Middle East, to North Africa, to any of the political turmoil that we may be experiencing in South Asia or the Middle East or Africa. So it's an American population. And even the immigrant population of Muslims is highly assimilated at this point. So I think we can have this conversation apart from the conversation of what should be happening in Turkey or Afghanistan or Israel or Morocco or Egypt. So that's one of my assumptions here. And so as an American problem, how should we approach this is my question. So the judge in the Michigan case dismissed the woman's small claims case unless she removed her niqab, and there was an appeal, but there was also an effort on the part of the Michigan Supreme Court to try to address as a general question of what should the rules of procedure and evidence allow the question of the niqab in the courtroom. And what the Michigan Supreme Court did was to adopt a statewide rule in 2009 by a vote of 5-2. The two women on the Supreme Court dissented. But the majority rule, the new rule, was that the court, quote unquote, shall exercise reasonable control over the appearance of parties and witnesses so as to, 1, ensure that the demeanor of such persons may be observed and assessed by the fact finder, and 2, to ensure the accurate identification of such persons. Okay, so to allow for observation, assessment, and identity, we have to let the judge have the power to decide whether or not they. The judge on the lower court level, Judge Puruk, I think his name was, he did not think that his expelling Gino Muhammad from the courtroom was in violation of that idea. He had to have her visible to be looked at by the rental car company representative who was claiming that she deprived him of, I don't know, $200 or $300. So he had to see her face to get justice. Okay. There are several interesting related cases that one could talk about. I won't get into them here. What I want to do is to zoom in my final few minutes on the menu of reasons that are given for why women cannot wear the niqab in the courtroom. One, the dignity and decorum of the court. It's almost as if the woman in a niqab was like someone wearing a bozo nose or, a clown suit, that it somehow offends the dignity of the courtroom to have someone come in wearing Muslim attire. Strike that one off the list. Okay. Right to confront, a more serious, I think, complicated argument. We do have this tradition, and the Canadians have it as well, of people who are being prosecuted or who are being sued having the right to confront witnesses and to confront their accusers. The question becomes, does the addition of something covering one's nose and mouth mean that one is no longer able to confront the witness? The witness is there to be cross-examined by the lawyers and the prosecutors. And so arguably, there is a degree of confrontation. But there's something culturally that in many of these cases, the judges who don't agree with the idea of covering say is that the covering impedes a kind of confrontation that the accused have a right to have. The next kind of argument that's made is also, I think, serious and interesting, and it's the argument that we want the courtroom to be an unbiased forum, and so we have to create neutrality by having people take off their niqabs, their yarmulkes, their priestly collars, and anything else that might bias the court or the courtroom. Interesting idea. I think I learned in this very law school 30 years ago to be suspicious of the N-word, neutrality, and so I am. But what's striking to me is that even when you take off all the gear, right, you still have people who look different. They have different hair types and skin colors and genders and accents, and so you can't really eliminate bias from the courtroom. And when we attempt to do that by saying no yarmulkes or no niqabs, we're just showing our xenophobia. I think we're exhibiting our fear, our anxiety about certain kinds of people or certain kinds of symbols being present in the courtroom. We accept all kinds of indicia of personality and background that might lead to bias, but we have to exclude others, the ones which I think invoke what Adrian Piper and others would call xenophobia. How do you accommodate a woman who wants to wear a niqab in the courtroom? I'll just end with these thoughts, and then we can talk, during the question and answer period about the First Amendment and the various RFRAs. But it wouldn't be that hard to accommodate. I mean, if you're concerned about identity, you could have the woman go into a closed room with a female officer and have her identify herself, and then when she goes into the courtroom, it's her. And as for the confrontation concerns, you could remind the defendants that they have the absolute right to ask all procedurally relevant questions and have them answered. Some courts have put up screens in the courtroom to block the view of the woman from the people in the courtroom. That's a kind of accommodation, thank you, which might be doable. You could have female judges and say, oh, guys, leave the courtroom. I think that's not so practical. But my point here is that there are lots of practical things you can do to accommodate the witness or the party. Why don't we want to do those things? Could be that we are intolerant and we are impatient with difference. The biggest, one of the most interesting ways in which social science can come into play here is that a lot of the social science literature doubts that, in fact, you can better discern the veracity of someone by looking into their face. Social scientists emphasize that we're actually quite bad at determining veracity by staring someone in the eye. That's not actually how we use all kinds of things: tone, inflection, body language, et cetera, to determine. So social science evidence was brought into the Canadian court, actually, and the Canadian judges had a very interesting response, which was that, well, this may be true, but our traditions of openness require this particular kind of confrontation, not, maybe so. So social science may be helpful in undercutting some of the arguments about a particular kind of confrontation, and philosophy may be useful in helping us better understand the roles of xenophobia and the racism, sexism, homophobia, et cetera, that they engender. Thanks.
What I'd now like to do is take questions from the floor, preferably at the microphone, for 7 minutes, at which time the red light will come on, and then Anita and John will have 4 minutes between them to respond to the collected questions, and then we'll move relentlessly to the other two very interesting papers. So while you're collecting yourself there to ask the questions, let me simply throw out one. Stanley Fish coined the term boutique multiculturalism with regard to ostensibly pragmatic views of multiculturalism, where it's essential what the example is, and there are obviously lots of times when any right-thinking people would want to tolerate it. And then, of course, as Andy pointed out, there'll be honor killings, which nobody wants to tolerate. So what if, for example, we made that form of child abuse called spanking a crime, and a defense of it is spare the rod, spoil the child, or one could talk about those religious injunctions to chastise errant spouses or the like. Are we still forced to draw some lines and be less robust in our pluralism? I can't imagine there aren't other questions if you wish to take the trouble of going there, or else we can just go into a general discussion among the panel. Or if you want to answer that while people who want to ask questions.
Well, your example, spanking, spare the rod. There have been compromises. I believe in the state of Georgia, you're allowed to spank so long as you don't break the skin. Then you become a child abuser. I think that. Can you use the mic? Sure. The example was spanking. I was pointing out that in Georgia, they do have a kind of compromise law where you're allowed to spank, but you can't break the skin. Breaking the skin is the line between child abuse and religious freedom.
And my whole approach to rights and the strengths of rights is they're highly contingent and highly politicized, and they vary across time in terms of their strengths. So conceptually, that could be that kind of right someday. And this is actually just to sort of clarify one part about Bob Jones. I think that the best thing I've ever read on Bob Jones continues to be Robert Cover's Nomos and Narrative, and I am utterly surprised at how few people have actually read it. And I think we could all get in a much better conversation about this stuff if we sat down and either read or reread that and then started to talk about what it means to put it on the line. And maybe we have not done that with race yet, and maybe we should. Maybe we have not done that with sexual orientation, maybe we should, but we need to have, I think those are the kinds of questions that Cover raises are the kinds of questions that would really enrich some of our conversations in these forums.
Very much enjoyed both presentations, and I guess it brought to mind, I mentioned this earlier, one of
Are we collecting questions?
Yeah.
John and Anita, you both raised, well, you started from religious accommodations, because I guess that's the order you received before coming here. And Kennedy mentioned gay accommodation, if that's the right word, and someone mentioned reasonable accommodation in the context of disability. The Niqab discussion, it has a religious angle, but it seems to be a wider notion of accommodation than just a religious one. And that's also what it was appearing in John's presentation. So would you really now advocate like that there should be a principle of pluralistic accommodation or a principle of minority accommodation? Since then it widens much more. Since so far religious accommodation has been seen as a thing in itself without being like an example of a wider notion of how to deal with pluralism and difference, etc.
Hi, thank you for the presentation. With respect to what constitutes confident pluralism, you talked about the third element being patience. I think it's very easy to be patient if you are the subgroup, where actually it's not easy to be patient if you're a subgroup who is not being treated equally. I say that as an Iranian American lesbian who now lives in the United States. Now, to Anita, maybe I can translate 3 words. Niqab is when women put from the eyes down. It's called niqab. Hijab is actually, translation of hijab is curtain. That's a curtain that woman separates the society with a personal domain. And then the third is we talk about hijab, we talk about niqab, and then all those protections that women have in the Middle East, where I'm from, is to separate domains, the personal domain versus the society. Now, why is it that the courts don't accommodate when there are victims of rape or other domestic violence? I think it has to be looked at whether or not is it because they're women and there's another way of society asserting their power over the domain or the personal domain of the woman? Or is it to discourage other women to come forward by showing an example, by setting an example? Thank you for the great presentation.
Thank you. I'll try to briefly respond to all 3 wonderful comments. The last one, I think that's a great example of the complexifying, right? Because we now have to deal with the ways in which gender and race and context matter greatly, and how the courts might be struggling to preserve some of that personal difference and personal separation, but also at the same time grapple with great public concerns. The RFRA question, I mean, so why do we have RFRAs in the first place? Because of the Native American peyote case, right? And in the U.S., we have the Native American case. We have some of the minority Christian religions explain why some states have dropped the requirement of full face for driver's license, not for the sake of the Muslims, but because some Christian women don't believe in showing their face on their driver's licenses. So we have some majority religions calling forth the need to apply RFRA. We also have some minority religions calling forth the same thing. And then finally, I think it's very interesting to ask the question about what kinds of accommodation should we be accommodating? Gay accommodation, disability, religion. In my paper, maybe not this particular version, but I have a paper around these issues in which I do talk about that frontally. And it comes into play with a case from a U.S. case in which a young high school girl wanted to wear a colorful headscarf to school because her Jamaican-American mother wore colorful headscarves. So this is an expression not of religion, but of culture and personality. And she was told by her school that hats were not allowed, and so she had to take off her scarf. And I kind of get that, and I kind of agree that it's more important that people be allowed to wear their headscarves and niqabs for religious reasons than that people wear their colorful scarves like this for purely, decorative reasons. I often wear the scarf, but it's just not the same.
Thanks. And so to the last question on patience, yes, I think that's a great point. I think I'm trying to set out some aspirational values, and then one question is patience toward what? And is it patience toward equal citizenship? And then what is preventing most acutely equal citizenship? And I think that's one reason that even though people left and right, no one seems to like this commercial, non-commercial line that I'm holding to, but one reason for it is I think it does go a long way, not all way, toward helping equal citizenship. But I think there are other ways to be patient, particularly with countervailing values and countervailing people. And then to the first two questions, most of my thinking on this grew out of some earlier work that I was looking largely historically at the right of assembly in the First Amendment and what assembly has been used for in litigation and social movements and otherwise. And that has typically or paradigmatically been dissenting minority groups, not majority groups. And religious groups are examples of that, but by no means capacious of the entire category. And so I've always intended, and I should have made clear, that the way I come at these issues is not for any sort of special protections for religious groups as distinct from any other minority dissenting group that can claim a protection in the private non-commercial space around something like a right of assembly.
Question for Anita, actually, involving another comparative angle, not the Canadian-American one, but the French-American
yes.
comparison. So I gather one of the claims in the French context is this idea that you are sort of sullying the pure Republican secular space by appearing in religious garb. And it's not as if we don't have this in the United States. In fact, in Pennsylvania, I think you have a religious garb law in your own state right now. And, so what do you think of that argument? And do you see the same kinds of debates playing out in the United States that play out in relationship to that claim that there's a secular space that's the Republican space, right? And that we must banish religion from that. Is a claim of accommodation vis-a-vis that principle the same as in another context?
So I'm very familiar with the French case, and actually the French example got me going several years ago when the French banned the wearing of conspicuous symbols of religion from public schools. They banned modesty head dresses. They banned large crosses, large Stars of David, yarmulkes. These are conspicuous symbols in the interest of this principle of, my French is terrible, laïcité, yes, right. And I think that it is very interesting that the American and the French were so similar, right, in so many ways, and yet we have this difference about how we emphasize the secularity goal as an official public goal. I think the French got it wrong. I think that I agree with those scholars, including feminist scholars, who say you have to look at the context of the French decision. It's the context of a growing problematic Muslim culture in France. And it was not just to bring to life laïcité, but rather to control the public response, negative response to having visibly different people become part of the French polity.
Yeah, yeah.
And on that note, we returned to two very, very interesting papers on the cash nexus. The first one being now Gotcham, Religious Liberty and the Financial War on Terror, and then Noam Stolzenberg on It's About Money, the Fundamental Contradiction of Hobby Lobby.
Okay, thanks very much, Sandy, and to the organizers of this gathering. I'm just starting my timer here so that I don't go overboard. Okay, so this is a distillation of a longer paper I've just finished. It's called Religious Liberty and the Financial War on Terror. Can y'all hear me well enough? No, I think I'm too tall for this thing. How about now? Can you hear me now? Better? No? Yes? All right, well, okay. Let me put it on top of this little laptop here. How's that? So, okay, good, all right. So, a longer paper dealing with the crackdown on Muslim charities after 9/11 in the federal courts, and the gist of the article is that in this area, this important area of Muslim American religious liberty claims, although it's not necessarily a representative area of those claims, the federal courts have applied a principle known as fungibility to dismiss claims by Muslims who have given money to designated terrorist organizations, either at home or abroad, that their donations are protected by religious freedom. So the fungibility principle holds that the intent behind a financial contribution or expenditure is irrelevant because money and intent do not travel together. The recipient organization can always use the money either to directly finance or to make less costly other purposes that are not contemplated by the giver. And I argue that the application of this principle has served to blur the distinction between legal and illegal enactments of the Muslim doctrine of zakat, or mandatory charitable giving, and also to override the First Amendment rights of both the givers and the recipients of zakat at a significant cost to both free exercise and free speech values. So that's the gist of the argument. Now, one byproduct of these cases, and there have been about 10 of them litigated in the federal courts in the years since 9/11, is a sweeping guilt by association dynamic that has implicated a wide range of Muslim American individuals and organizations with no plausible connection to terrorist activity. And that dynamic has in turn galvanized efforts by Muslim American organizations and also by civil libertarian groups working with them to ensure that Muslim American charity does not find its way onto the front page in this way ever again. I actually litigated one of these cases as a lawyer several years ago. That's how I got into this subject, involving a Libyan immigrant to the United States who in the 1990s ran a Boston-based Muslim charity. And when I first encountered his case in early 2005, he was in the process of suing the Immigration and Naturalization Service for his citizenship in a naturalization delay case. It turned out to be the wrong lawsuit to bring. He was indicted for tax fraud charges involving the administration of the Muslim charity that were scarcely distinguishable from material support of terrorism charges. That case was unique, and so were all of the others that are involved under this rubric that I'm calling the Muslim charity cases. And it's also true that there are many cases involving Muslim Americans that have no direct or even indirect connection to the issue of terrorism and the ramifications of 9/11. But the Muslim charity cases of the post-9/11 era have, to a degree not equaled by other contexts, tested, I think this is true also of the religious headwear cases that Anita was talking about, have tested the perceived relations between Muslim belief and American citizenship. That is, they have forced a confrontation between religious liberty and national security that is not forced in other litigation and legal doctrine involving Muslim Americans. And I'm thinking here in particular of the controversy surrounding the so-called Ground Zero Mosque or the application of Sharia law in American courts. Both of these are symptomatic of broader Islamophobic currents. But as a matter of constitutional law, they're kind of blips on the radar screen. They're here and they're gone the next day. They're not really hard cases of constitutional law. The Muslim charity cases, on the other hand, I think are, or at least they should be perceived as such. The federal judges who have overseen these cases seem to believe otherwise. They found a handful of due process or other procedural problems in the handling of a few of these investigations, but otherwise have repeatedly held against the religious liberty claims in Muslim charity litigation based on some version of the dictum that, quote, there is no free exercise right to facilitate terrorism. Okay, that's the phrase that you see in a number of these cases. Judge Kaczynski on the Ninth Circuit has a particularly influential version of this that's cited in the case law. And what I want to say about that is that there is something both self-evidently true and deeply misleading about that statement. And in the time remaining, I want to say why this is so, and then also connect it to a few other areas of doctrine, including campaign finance, elite financial institutions, and this being the Hobby Lobby conference, I want to say a little bit about the contraceptive mandate. Okay, so the basic point, and this resonates in a general way with what Naomi is arguing in her paper, is that there is a political economy that frames the religious liberty discussion in these contexts, particularly the Muslim charity context, and that we can't see these cases solely in doctrinal or theoretical terms. That's to say, we can't reduce them to this mantra that there is no free exercise right to facilitate terrorism. Because these cases are also the products of a very particular political economy of American Middle Eastern relations that prevails at present. And this problem of framing then helps also to explain what's wrong with this judicial mantra and also with the legal academic quest for a neutral and general theory of religious liberty that can rationalize and justify the hard cases of church-state law. Okay, so just a minute or two on what these cases are actually about in sort of nitty-gritty terms. So material support of terrorism law is a mix of administrative and statutory law. The key statutes are the 1977 International Emergency Economic Powers Act, or IEPA, and then the 1996 Anti-Terrorism and Effective Death Penalty Act, EDPA. The first of these statutes, IEPA, permits the president to cut off international financial flows into and out of the United States in the face of a national security threat. And it was pursuant to this statute that in 1996, President Clinton issued an executive order that began the process of naming particular individuals and groups as, quote, specially designated terrorists in that particular executive order because of the threat that they were perceived to pose to the Middle East peace process, and then by extension to national security, which is the trigger for IEPA, right? And so the near total domination of the current Treasury and State Department designated organizations list by Islamic and Muslim-sounding names began here, began in 1996 with this executive order. The second statute, which is EDPA, permits the criminal prosecution of anyone who knowingly gives material support and resources to one of these designated organizations, where material support is defined to include any property, tangible or intangible, accepting only medicine and religious materials. So the Bible or the Quran can be given, but aside from that, there are no other exceptions. Okay, so the list, I said, is dominated by Muslim organizations and individuals, and so too the material support of terrorism cases that have been prosecuted in the federal courts since 9/11 are cases that involve, in almost every single instance, Muslim defendants, or if it's a civil proceeding challenging the designation process, it is a Muslim plaintiff, and these cases have not gone well for the individuals involved. And in the 10 major Muslim charity cases that I write about, there are only, as I say, 2 or 3 instances in which there was a due process error found in the designation, but none in which a substantive claim of religious liberty has prevailed, okay, in the criminal context or outside of it. So the question is, why? Now, the most obvious answer to this question, why these claims have failed, is that these organizations are in fact terrorist organizations, and that the people giving to them are facilitators of terrorism. If true, this would obviously explain why the federal courts have held that there is no free exercise right to support terrorism. Okay, so there is a debate about just how important a role Muslim charities have played in the proliferation of terrorist incidents over the past several decades. The sympathetic position, which is represented by the ACLU and a handful of scholars, maintains that there has been a kind of blanket attribution of criminality that's based on tenuous and faulty evidence, and that creates the mistaken impression that the war on terror is a war against Islam. At the other end of the spectrum, a group of sort of Washington counterterrorism outfits and analysts. So these are folks like Steve Emerson, Rachel Ehrenfeld, David Yerushalmi, the lawyer, who argue that the whole thing is corrupt. The whole industry is corrupt. It is in cahoots with jihadist Islam. And then in between this poll, you have, for example, the staff report of the 9/11 Commission on financing that found that a couple of these charities were in fact linked to armed jihadist fighters. One of them, in fact, was found to have provided some funding to al-Qaeda. That's the Al Haramain Foundation in Oregon. But the report otherwise found that there were substantial civil liberty problems with the crackdown, and that the government had failed to distinguish between apparent links in many of these cases and actual funding on them. So depending on how you construe all that evidence, you could say very simply that where a claim of religious accommodation is made in connection with a case alleging terrorism, the religious liberty claim will lose on the simple grounds that RFRA, or the Free Exercise Clause, protects belief but not conduct, right? So in that sense, we're nowhere beyond the Reynolds case in 1878. And it's also possible to conclude, as Gregory Sisk and Michael Heise have concluded, of the larger universe of Muslim American religious liberty claims from 95 to 2006, that federal judges have internalized popular fears of Muslims as dangerous to national security. There's probably something to both of those interpretations, but neither of them is really an account of legal doctrine. And legal doctrine is clearly doing a lot of the work in these cases, particularly this concept of fungibility. So in the paper, I go through and try and engage with doctrine at two levels. One, the principle of church autonomy and what that has to do with the crackdown on Muslim charities, and that involves a comparison to the scalpel approach of the British. I won't go into that right now because I don't have time. But then there is the fungibility principle, and what's important to note about that is that though it is enshrined as a kind of quasi-constitutional matter in the Humanitarian Law Project case of 2010, it actually developed in the lower federal courts in the years prior to, the 5 years prior to 2010, in connection with this Muslim charity litigation. That's sort of where it comes from, and that litigation also appears to have been the source of the claim that a moral person, a corporate entity, can claim free exercise protection. There's a suggestion in one of the Hobby Lobby, the contraceptive mandate cases, that this is an issue of first impression in those cases, but in fact, you see it raised already in some of these cases, and for all I know, it's raised even earlier than that. So I've got 2 minutes left, and I'm going to have to fast forward through a bit of my remaining analysis. So what's the problem here? Okay, what's the problem with this state of the law? One I've already alluded to is a kind of sweeping guilt by association dynamic. These cases implicate not simply the organizations in question, but the whole range of individuals who contribute to these organizations and the people who are supposed to be their intended beneficiaries. And if you want Exhibit A, in that case, look at the list of unindicted co-conspirators in the Holy Land Foundation case, which is the case involving a Palestinian American charity in Dallas, in which the Department of Justice named virtually every single Muslim American organization as an unindicted co-conspirator in the case, and then dropped all of these names in the course of prosecuting the defendants in that case. So, I mean, it seems to me that that is a clear problem. But fungibility is here to stay. It's not going to go away. It's going to outlast the war on terror. And so the question is, what else is a problem here, given that there is this underlying issue of the relationship between money and religious freedom? And I want to suggest that there are two other issues. One is simply the comparative treatment of more elite financial institutions. So it's only in the last few years that the government has began to crack down on other organizations that have been found to violate some of these same sanctions. Banks, right? HSBC, Standard Chartered, and so on. Not through criminal prosecution and punishment, but through digestible fines and deferred prosecution. And it seems to me that that's a clear illustration of this sort of political economy of contemporary federal criminal law. They call it the too big to fail problem, translated into this context, if you like. There are no religious liberty claims in these cases, so far as I can tell. And nonetheless, the concept of financial risk does not correlate with national security risk in anything like the same way. And then my last point, if I could have 30 seconds, Sandy, just to make this last point, it would be that It involves the connection to the Hobby Lobby case, and in particular to Citizens United. So fungibility is obviously a central concept to the Citizens United litigation. The idea there, of course, is that money converts into political corruption, and as we know, the Supreme Court has held that that congressional determination does not, must yield to a more absolute reading of the First Amendment speech clause. And it seems to me that there's an issue here of how fungibility works across the whole range of cases that implicate, right, the constitutional status of money in religious liberty or non-religious accommodation context. Hobby Lobby is part of this development, and we'll see whether a more absolute reading of religious freedom applies at the intersection of corporate power and the administrative state. But in any case, it seems to me whatever the answer is, I have no idea how the case is going to be resolved, whatever the answer is probably not going to lie in the realm of doctrine and the parsing of Supreme Court cases. It's going to involve the political economy of those particular cases, which involves the power that the corporations have over their employees. Let me stop right there and yield the floor to Nomi, because she's going to pick up a similar line. Maybe I can add a few more thoughts at the end. Thanks.
I'm not going to have Malik's problem with the mic. Does it seem well situated? Okay, so I'm also talking about the relationship between religious freedom and money. That's why Sandy cleverly paired us. But I'm going to be focusing exclusively on the contraceptive mandate issue. Right after the court granted cert in Hobby Lobby and Conestoga Woods, Linda Greenhouse wrote a wonderful op-ed that I'm sure a lot of people wrote. And she basically said, look, the issue in these cases, it's not about religion in the usual sense that we refer to religious practices of the sort that are protected by the Free Exercise Clause generally. And it's not about the rights of business corporations either. It's about sex. And my response to that is, it is about sex, and it's about religion, but it's also about money. And since sex and God have gotten lots and lots of attention, like Malik, I want to talk about the money. So my basic point, religion clause jurisprudence is occupied, as someone made earlier reference to, with the question, is religion special? What I'm saying is money is special. There's something special, different, and peculiar about money and financial actions. And therefore, there's something special and different about any governmentally mandated financial obligation. Whether it's a mandate to pay taxes, or a regulatory mandate to make a monetary contribution, whether it's to a benefits plan or an environmental cleanup fund. I might even go so far as to suggest, but I'm not here to make this argument today, that even a legal obligation to pay wages is a government, but we'll leave that for another day. Certainly, regulatory mandates to pay money, regulatory mandates to pay taxes, there's something special about them that I want to examine. Another way of making this point is very much in agreement with Riva and Doug's presentation. If I paraphrase their conclusion, Riva and Doug say it's about complicity. And what I'm saying more specifically is these cases are about financial complicity, and there's something special about that. And once I think we haven't thought enough about what it is. What is financial complicity? And I think once we take the time to do so, that has implications for the two sides of the analysis, both our understanding of whether or not there's a burden on free exercise, and also the other side of the equation pertaining to an assessment of the state interests or third-party interests, which in my opinion are the same thing. So let me begin with the burden. My basic point here is that for those of us, and I include myself, who think that these claims to a right to a religious exemption from the contraceptive mandate should be denied, that making the case for that on the grounds that there is no burden or the burden isn't substantial, that's the wrong target. I feel strongly that that's the wrong way to go. It's a mistake to deny the existence of a burden, indeed a substantial burden in these cases. And I think it's a mistake in a number of respects. First of all, it's disrespectful of the religious beliefs of the people who are asserting this claim. And by the same token, it's disrespectful of basic principles of religious freedom and freedom of belief more generally that people who are making this denial hold dear. More importantly, maybe, I think it's a position that forces, let's say, progressives who are making this claim, it's forcing progressives into taking positions about the nature of financial actions that are, I'll stop saying we, that are deeply inconsistent with our own progressive commitments. And I understand the argument that this is strategy and it's strategic, but I think anytime we find ourselves making strategic arguments that are deeply in conflict with some of our most fundamental principles, that should give us pause. The last way in which I think this is a mistake for progressives who want to justify the conclusion that these claims should be denied, I think that failing to recognize the special characteristics of money that I would say support the recognition that there's a substantial burden blind progressives, blind us, from seeing that there are much stronger, I think more intellectually defensible arguments to be made in support of that conclusion once we really come to grips with what the special characteristics of money and complying with governmentally mandated financial obligations are. So the first point that I think follows from the analysis of money that I haven't given you yet, and we'll see how far I get in giving it to you, but the first conclusion that it leads me to is the burdens are real and substantial. But the second implication, the second conclusion, so I'm going to sort of lead with my conclusion and then I'll try to work my way back, is that I think once we recognize the nature of the burden, we'll be much better able to see that the kind of burden that is involved with financial complicity always correlates to state interests that override the right to be free of that burden. Why? Well, what is the state interest in enforcing the kind of financial obligation that religious objectors experience as making them complicit in the commission of other person's actions which they deem to be sinful? Well, if I was going to be really simplistic, instead of saying it's about money, I'd say it's about taxes. And I would try to do the fancy footwork that I think some of my tax colleagues might be able to do, which would sort of show how the Affordable Care Act, which is this crazy hybrid, quasi-public, quasi-private, cuckoo compromise, is functionally equivalent to a system of taxing as well as funding, as Marty said, public benefits. But I'm not here to make that case. I don't have to make the case, because it doesn't matter whether technically, not just the tax alternative to the contraceptive mandate, but the contraceptive mandate itself, or perhaps more precisely, the three options employers have a choice between three financial obligations that they can comply with. They can pay the benefits for a plan that's in compliance with the contraceptive mandate. Alternatively, they can provide employment benefits plans and pay a fine, or they can disband employee benefits and pay a tax. I think you might be able to make the case that that whole network of choices, but you got to comply with one of those financial obligations, is functionally analogous to a tax. But even if not, it doesn't matter. Even if we say tax isn't the right label, it remains the case that this kind of governmentally imposed financial mandate has the following two characteristics that it shares in common with taxes. On the one hand, it is what the ACA is a system, as Marty said, it's a system of providing a public benefit, right? More than that, it's a system for ensuring that money is raised from the populace that then is funneled into the funding of that public benefit. The usual way we raise money from the populace is through taxes. Here we have this cockamamie system that's a combination of tax-funded public subsidies and a variety of private delivery systems. I don't think any of that should obscure the fact that at the end of the day, this is a system for collecting revenue and funneling it into the funding of public benefits. And the basic point here is that for the same reason that we do not, I don't think there's any controversy about this, see Lee, we do not, if it were a straight up tax, right? Nobody has the right to a religious exemption from paying taxes, even if they have deep-seated religious objections to paying taxes in general, or for paying taxes that are spent on activities that they deem to be deeply sinful. Not because there's no burden, but because that would interfere, that would just undermine the government's ability to do what it's authorized to do, so long as it is collecting revenue, collecting taxes, and using that money to pay for public benefits within other constitutional parameters. So that's my punchline. The way I get to that, I haven't yet provided you with my analysis of money, but let me get at that in the last 2 minutes.
You got 4.
Oh, I have 4 minutes, wow. But by raising the question, why aren't we, I've never before been able to say about anything I've written or thought about, it's that simple. I've never felt so, I think it's that simple. Yet, well, maybe I'm completely wrong. Maybe that's the reason why no one's talking about it in these terms. But if I'm right, so why aren't we seeing it for this? I think there are 2 reasons. One is the cockamamie nature of the ACA, but I think it's also because we are confused about money. We have very hazy conceptions of money, and we actually have 2 radically different and in certain ways totally contradictory ways of understanding money, but because we don't think about it too much, we don't parse them out. What are those 2 radically different ways of thinking about money? Well, I think that the people who are claiming, who are making the I'm being forced to financially facilitate sin claim, that claim of the burden is based on one of these 2 opposing ways of thinking about money. It's a conception of money that understands that money is something that connects us to one another, and that any one person, could be private person's, financial act has effects ultimately on everyone else. So money is something that binds us together, makes us dependent upon one another. It's really essentially the same logic that underlies the theory of material support and fungibility. Because of the fungibility, it's something special about money. Anytime I buy a good or pay for services or pay a tax, it doesn't matter. When I give that money to someone else, on the one hand, I can't control how the recipient uses that money, yet I remain responsible to a degree for how that person uses the money because I've enabled them. We all understand that. We all understand that when the employers put money into the benefits plan, they're facilitating the uses that the employees make. That's the point of the system. That's why we make employers put with it in order so that they can financially facilitate access to all of the health services that are provided under the plan. These employers believed that there's certain services that are tantamount to murder. That's their belief. So they are, I think, absolutely right to think that from the point of view of their religious beliefs, they are being made complicit in an act of murder. Now, I think that the theory of money, of how money works, that they're relying upon, is actually a theory not just that progressives should want to embrace, that we ordinarily do embrace. Contrast it to a very different way of understanding money. And by the way, my view is it's not that one of these is false and one of these is wrong, it's that money really has a double character. The other way of thinking about how money works and how our financial actions do or don't affect one another is really obedient to the logic of possessive individualism, to the logic of libertarianism, if you will. That's the view that holds that my money is an individual possession and its disposition is obedient to my will, right? That's really the theory that's embodied in the endorsement theory of money as against material support, right? As if when I give you money, I can dictate how, my intentions will dictate how you use it. The whole case for a libertarian approach to regulating the economy, that is to say, not regulating the economy, is contingent on that understanding of money and financial actions as being money isn't something that connects us, money is something that separates us and individuates. None of us bear any responsibility for the consequences of what other people do with the money they receive as a result of our. I think sometimes that's a correct view of money, sometimes that's an incorrect view, but I think that's a view, that progressives generally don't and shouldn't want to endorse. And if I have time in question and answer, I'll make like Mark Tushnet yesterday and tell you my, I guess, amateur history of theology thoughts about how the first understanding of money as an agent that connects us and that therefore not just justifies but requires that government regulate financial activity is not just a modern progressive view, but that actually was the traditional theological understanding of money and financial activity. And what my own personal armchair, amateur history of theology analysis of what's going on today is that the position that religious conservatives are taking in the current facilitation of sin cases is a curious and internally contradictory hybrid of the traditional theological understanding of money, which sees it as something that thrusts us into relationship with those with whom we're into an economic relationship so that we bear responsibility for what the recipients of our financial transactions do with that money. So they have a deeply non-libertarian understanding of how money works. And yet, not only is that inconsistent with the libertarian free market approach to the ACA and regulation of the economy generally, that's well known they're associated with, but it's actually deeply contradictory, or I'll just throw this out there without defending the claim, it is a demand, it's an understanding that is, I would say, logically, mathematically impossible to accommodate. And that's an understanding that traditional theology had, and that's been lost.
Unfortunately, we have time only for about 3.5 or 4 minutes so of questions, and then about 3 minutes of answers, since I take my orders from Mark, and there is another panel in this very full day of panels. So, Marty? I think. Okay. Rather than spend time, why don't you just start and somebody else will.
Don't be sorry to tell you this, it's not that simple. like everything else that you've written about. I agree with all of the
for my
complexities that you raise about money and complicity, but in Hobby Lobby itself, for 3 reasons, I'm not sure it works. Number one, of course, is that when it's coming from the employer, it's recompense for labor. So it's to a certain extent, it is the employee's money. Secondly, and complicated in Hobby Lobby, they don't own the company, and therefore it's not their money, and in their brief, they've basically disclaimed the money theory. And third, their theory is that as directors of the corporation, they have to ensure that the corporation comply with the federal law, and that's what makes them complicit. They've given up more or less on the money claim, which was never very central. And the third is that according to the government, I don't know how this complicates it, when you actually spend the money by providing reimbursement for contraceptive services, you are saving the plan money, they're not spending it, they're saving it, which is why under the accommodation, when Aetna spends the money, it is saving money because the prevention of unintended pregnancies actually in the long run means they spend less, not more. None of which undermines anything else you're saying, it just makes Hobby Lobby maybe not the best case for it.
Yep.
Naomi, I wonder if you have any thoughts about taxpayer spending in the kind of voucher type cases and so on. It seems like that is consistent with the argument you sketched out here.
Yep, you have more time. Good.
Oh, God.
Go to it.
Well, so first of all, I to the extent that I'm in the middle of all this, so I don't have good answers, solid answers to either of your sets of questions, but I'll be thinking about it. The little bit of thinking I've done, and I know Malik also has thought about this, about the voucher cases. I mean, the logic that Malik is describing of fungibility, and it's the same logic that I'm proposing underlies the way that the burden of financial complicity is thought about. It's the same logic that, at least until recently, prevailed in establishment cases, and in particular school funding and government funding cases, right? It was the old idea that because money is fungible, that tax money can never go to the support of religious schools, because the case is, it's just the same as the logic in the terrorism material support cases. The idea that by virtue of intending, in this case would be the government's intentions to only fund the secular aspects of religious schools and the secular education going on in religious schools, that because that's the only thing we're giving money to support, the money will obey our intentions. The logic of fungibility, I think maybe first was presented in the now kind of disappearing separationist view, which said, well, no, money, even if you could cordon off the dollar bills that came from the government and only spend them on building and maintenance and secular textbooks, that's freeing up money to be spent elsewhere. So that's just a beginning, which is to say that logic has obviously been, step by step repudiated to the point, sort of culminating in the, what shall we say, judicial sanctification of vouchers. So I'm interested in thinking more about how these ideas have been analyzed and should be analyzed in the context of government funding, taxpayer spending on education, including religious education, whether it's going through vouchers or going directly to religious schools, but I haven't thought it through enough yet. And since I don't want to monopolize, Marty, I'm going to think more.
I just want to sort of offer a vote of confidence in what Naomi's doing, because I think what she's suggesting, Rich, is that a lot of the confusion of the religion jurisprudence is a confusion about money and not about religion per se, or about how to accommodate religion. And it seems to me that's exactly right, and that does help to explain, but not to reconcile, because there is no reconciling to be done. The parochial funding cases, with this kind of case, Hobby Lobby, with the Muslim cases that I was talking about. So I think you're right about that, and I wouldn't yield. I don't know who the previous speaker was. I don't think that dealt with the money issue at all. Actually, I mean, I think money. They may have disavowed this in their brief, but it seems to me the idea that we are supporting, we are facilitating, we are enabling this this to happen through some kind of financial relationship is still part of the case, right? Now, I don't know what their sort of strategic motive was for disavowing. That's an interesting question about why they disavowed that in the briefs. But it could still be there, even though it's not in the brief. So I think you're on the right track, is what I would say.
Thank you.